Arey, Nazish, 1 minute, give me. I want that table, small table.
Where?
Table here.
There is no small
Mayur ko bulao na, please.
That's all small table and saman bana hai.
Yeah. We are discussing today section 24, if I'm not mistaken, 25, 25, 26, I think, is it? 27 or 27. Yesterday we had discussed 24, 25. Yeah.
Yes, sir. I completed 26.
Some judgments also. No, that. Where is that?
वो नहीं है, that is good stuff for there.
Okay, okay. Yeah. Some I have circulated some judgment also, one or couple of judgment. You must be aware of it, no? That will solve the question the student has asked me. Nazish, can you give me that water? Yeah. Yeah, one of the question which the student had asked me was a very interesting question relating to section 24 ke andar. Just I would like to, because I have done some research on it and shared with you the material. I will just comment upon it today. There is one judgment which I have shared, that is of Pakri Swami versus State of Tamil Nadu. उससे पहले एक जजमेंट या yes. In Pakri Swami's case, here the observation of the Supreme Court in this case was that evidence and record, there must be corroboration required. Here the confession was made to the village administrative officer. See, I'm not reading the entire judgment of Justice Kurdukar. It's a beautifully written judgment. Whether what is the effect of a confession made to a person other than the magistrate. A judicial magistrate confession 164 normally, that's a judicial confession. Extrajudicial confession, which is corroborated by other. Here, in this case, a murder case. In a murder case, the accused person made the confession to the village administrative officer after a gap of 4 days and gave confessional statement. And it was recorded. Then no explanation whatever was given by the appellant as to whether he was during the 4 days. The court below rightly held that appellant was absconding. Now, absconding evidence is admissible under section 8. You know that here is a motive, preparation, conduct is held available. Then the Supreme Court held that after going through the judgment of the court below and the royal court, oral and documentary evidence on record, it was satisfied that the impugned judgment below and they did not suffer from any infirmity. That is the beautiful judgment. Then somebody asked me, yes. Yeah, ek minute. There is one more item which we would like to throw light on section 24 is with regard to the because the act is not defining the confession, but I have been able to cull out some interpretation and definition from the judgment of the Supreme Court as well as the English court. Yeah. What is the other judgment, Kumar, I had forwarded to you?
Sir, the other one is Chaman Lal versus State.
Yeah, Chaman Lal's judgment. I will cover it. Chaman Lal, yeah. Uh, there are several types of inducements which are given here. Uh, yes. Mm. Yeah, Chaman Lal versus State of Jammu and Kashmir, 1310. That is one of the student raised a question, asked me, what is the advantage gained by evil to be avoided must be a temporal nature. It's a very interesting question, and it is actually arising from the section itself. Sorry, I did not answer it correctly yesterday. Today I will explain to you this particular expression in section 24 of the Evidence Act. When you saw that, when you see, when you, I'll just see the Bare Act open kare tha, section 24. Yeah. I'm just trying to find my Bare Act. Give me 1 minute. Please don't close this. I want a water wala. Water the pani ka. Malum karne hai mere ko. Don't close it. Anything which I require.
It's on live.
लाइए पानी भर के लाइए. अभी बंद करें. Yeah, this I would like to answer this question, which one of the student had raised this. It's a very important question. So in the confession part, section 24 के अंदर आप सीखे हैं, the a confession made by an accused person is irrelevant in criminal proceeding if it's making the if the making of the confession appears to be appears to the court to have been caused by inducement that we have explained, that of a promise will be explained ke reference to charge against the accused person proceeding from a person in authority. So this I will explain to you what is the meaning of person in authority, a reference to the judgment of under the Indian Customs Act, then which could appear to him reasonable for supposing by making it would gain advantage or avoid any evil of temporal nature in reference to proceeding against him. Now, this particular expression I would like to explain to you here. What does it mean here? Now, yes. Now, in order to appreciate it, the reason is that here, why this particular, especially a person may be told, you take an oath or you go to some, take the name of some god, go to some church, go to some dargah and make confession. If you make the confession and you will be free from, the God will forgive you. And these are the inducements which may be given. Whether such temporal nature, whether something which is ecclesiastical promises which are given. Now, some of the, some judgments in that regard, which I will quote you. Now, what happened? Whether the as the reason for admissibility of confession is found on the presumption that the confession made under certain condition are untrustworthy, it follows confessions induced by spiritual or moral extortion. You may go to a Baba, you may go to some particular a man having an evil spirit. These are the police officer may tell you, or the any other person may tell you, who is interested. You make this confession before a spiritual authority that they shall not on principle be inadmissible. They are not inadmissible, and as such extortion do not lead to falsehood but to truth. In fact, a person is driven if he is told that if you go to a particular आप भगवान के पास जाके मिन्नत मांगेंगे and you accept your crime and you will reach eternity, isn't it? बहुत सारे चीजें, वो उस बुनियाद के ऊपर your confession is taken. And some of the courts have said that such confession which are taken from a person, they cannot be told they are inadmissible. Then exactly said, see, these are the confession whether they are made to clergyman, any other person. The reason of the rule is that stated by the authority and law. It seems difficult to imagine that a man under spiritual conviction and the influence of religious impression would therefore confess himself the guilt of a crime which he was not guilty, or a man under strong sense of spiritual relation with God could hope to please God by falsehood, that the confidence created between him and the pastor, or being thrown out of the guard by his confidence, should induce him by not to confess that the almighty nature naturally, but induce him to confess falsely such spiritual conviction or spiritual extortion seems from the near religion and most likely of all motives to produce truth. So the author is saying here, I am reading from the commentary of Munir, which says that here people have fear. Now, many people, Christians, go to the church on Fridays, on Sundays, they make some confessions. You know that the revelations. You may have committed a crime and you go, you just want to, you want to have some spiritual satisfaction, and you don't normally lie to a pastor, to a church priest. And similarly, you may go to some mandir and you may tell the pujari, I committed this crime. So when a crime is committed, when you are told that if you tell the truth, you may reach. That is why it is called temporal nature. I mean, you are avoiding the evil of temporal nature. Temporal nature is something temporary and it is not eternal. That is the meaning between, if you see the Google dictionary, माल के देखेंगे. So when a person primarily, he may be having a superstition, I believe that अगर मैं सच बोल दूं, confess कर दूंगा, शायद मुझे भगवान माफ कर देगा. So that confessions also, a religious man is examined by the police officer and he says he made the confession voluntarily and they are admissible. That is what. If temporal hopes exist, he may lead to falsehood. Spiritual hopes can lead to nothing but truth. That is what the one of the judgments says, the English judgment of the 1842, joy by confession. Then the Indian Evidence Act recognizes this rule. The rule means evil to be avoided must be temporal nature, is recognized by the Indian Evidence Act here under the provisions of section 24. Then it says the use of extortion invoking the terrors of punishment predicted by the theological belief cannot therefore bring the confession within the exclusion. Consequently, confessions induced by expressions such as kneel down. आप kneel down, church के अंदर जाएंगे आप, many Christians will kneel down. Even the Muslims will kneel down in the prayers and tell even Hindus when they go to the some Baba, some Pujari Mandir ke andar, you kneel down, you seek prayers from the God, you seek confession, you make the forgive me, I committed sins in the matter. Kneel down, tell the truth in the presence of Almighty. This Such matters are also come before the court. They don't run your soul into more sin, but tell the truth. They don't add sin to Almighty, but you do. So confession obtained by saying it is good to speak the truth, fear the God, and tell the correct thing, similarly held to be admissible as one obtained by moral extortion and not by inducement. So if you have gone and admitted the crime before a Baba and some religious leader, and religious leader in turn was examined by the police officer, then you cannot take a somersault that what I said before Baba is not to be taken as a confession. The courts are accepting this. So section 24 says that it doesn't amount to what you call it, a promise. You are making a voluntary confession and there is no bar. So a confession caused by a moral extortion, and stands on the same footing as on the confession caused by religious extortion, and therefore confession induced by the moral confession, such as I hope you will tell it because Mr. So-and-so can gill effort to lose the money. If you have committed the fraud, this is what here a commentary says here. So that is the meaning here. The expression which has been brought in section 24, advantage is gain or evil to be avoided must be of a temporal nature. Confession induced by religious moral extortion are admissible under the Indian Evidence Act. Please note that. Oh, interesting. Very interesting topic on this point here. Yeah. Then the on this judgment which I found of an English judgment is called E versus Mohanlal for Allahabad 46 181. I did not find it on the net. If anybody can lay your hand, let me know. E for England, E versus Mohanlal for Allahabad, page number 46. It is at page number 181, AWN, Allahabad Weekly Notes, page number 184. Kumar, if you can lay your hand, let me know. If not today, maybe by tomorrow, dekh lenge. This ends our illustration with regard to section 24. Anybody want to ask
Sir,
me?
time.
जी बोलिए. Any problem? You all can hear me, no? Kumar?
Yes, sir.
Anybody has any question now? The student who asked me a question, I would like to compliment him on the provisions of advantage to be gained or evil to be avoided must be temporal nature. Sorry, I could not answer yesterday because I had not deeply paid my attention to the subject. I have now gone through and done some research on it. I am able to lay my hand in that. Yeah. Then yeah, you know that under the provisions of the Indian Evidence Act, it is open to the investigation agency, so who are supposed to be an authority, for the purpose of ascertaining the identification of the voice required to the accused to lend the sample voice. A sample bhi mangenge aapka. Can you say that the police officer has taken my sample forcefully? It doesn't amount to confession. No, that is one. Then moreover, reference can usually be made to provisions of Identification of Prisoners Act of 1920. Under this act, essentially intended to make provision relating to authorizing taking measurement and photographs of convict and other to record, making note of the identity of the person. Isn't it? Section 5, I read out to you earlier. Now, under the provisions of CRPC also, there is a new provision added. The magistrate can order the police to take identification, measurement, which is the relevant section. Anybody can point out to me from investigation. Identification of, that is section 54A, padhenge aap, where a person is arrested on a charge of committing an offense and his identification by other person is considered necessary for the purpose of investigation of such offense, the court having jurisdiction may request the officer in charge of a police station direct the person so arrested to identification by any person, such manner as the court may deem fit. So यहाँ पे provided that the person identifying arrested is mentally, physically disabled, such person identification shall take place under the supervision of a judicial magistrate who shall take appropriate steps to ensure such person identifies. So identification लेने के लिए provision है. You cannot say that here that is hit by the provisions of what you call it, section Article 20 subclause 3 of the Constitution of India. So you are not being told to forcefully, but the law registered even under section 73 of the CRP of the Evidence Act, the court can compare your handwriting and signature. You know that here. So you cannot say that that is the confession taken under duress or under force by the authority that permits here. Now there is one more section with regard to identification. Padha maine aapko. So remember the provisions of Identification of Prisoners Act of 1920 and section 54A in the CRPC, which has been added recently in the year 2000, where the magistrate can order the identification being done. Because under section 9 of the Evidence Act, evidence with regard to identification is permitted. यहाँ the court is more specific with regard to the identification of a person, and he cannot take up the plea कि मुझे हाथ मत लगाइए, मुझे पैर मत लगाइए, मेरा measurement लगाइए. They will do that here with a view to find out whether you are the person committed or not. The measurement given by the witness is tallying or not. ये सब देखना पड़ेगा अब. So similarly, yeah, that is the provision. Even photographs are taken. You know that here the magistrate can direct photographs to be taken. It is possible. Then you know that the case of Malkani's case, where the voice identification was taken, R.M. Malkani versus State of Maharashtra, that is EIR 1973 Supreme Court, 73 Supreme Court. वहाँ पे you know that that's a famous case of a coroner of Bombay who was arrested solely on the basis of the his confession which he made in the tape record evidence. So whether the tape record evidence is is in violation of the provisions of Article 20, the Supreme Court rejected it. Similarly, the retraction of a confession is a weak evidence which cannot be taken here by the court. So it is not just the confession which is recorded under 164 of the CRPC. There are various methods where confessions are recorded here. Now, there is one thing. So voluntary confessions are embodied in section 24, 25, 26, 27 of the Evidence Act, which you know that. Today we'll deal with section 27 onwards. Now, you also want to know the Parliament attack case, that is the state of NCT Delhi versus Navtosh Sandhu's case, that is a EIR 2005 Supreme Court 3820. When I was taking the lecture on CRPC, I had given you the facts of this case. So you will come to know what is admission, what is confession, how the Supreme Court has distinguished it is very important. So I had told you earlier, the Evidence Act, though is defining the expression admission in section 17, but it does not define the expression confession. But I would like to enlighten you with the definition of the meaning of confession, which has been given by Sir John Stephen in his Digest of Law of Evidence. Just make a note of it. Now, what is confession is a relevant question. Please note that here. The expression has not been defined in the Act, nowhere. Now, Sir John Stephen in his Digest, that is called Law of Evidence, that is Article 21 in the Digest, which was prior to the drafting of the Indian Evidence Act. He had made a draft in which he says a confession is an admission made at any time by a person charged with the crime, stating or suggesting the inference that he has committed the crime. So it is basically an admission where the man says that I have committed the crime. Now the word suggesting inference that is committed the crime created some difficulty and confusion in realizing the true import of the expression, and which was explained by Justice Lord Atkin in Pakala Narayan Swami's case. That is Pakala Narayan Swami versus Emperor. That is, take down the citation of the judgment and we'll discuss one moment. That is with regard to circumstantial evidence and also how the confessions are important. That is AIR 1939 Privy Council, page number 47. Now, what does Justice Lord Atkins says in Pakala Narayana Swami case? I will just summarize in just 1 minute. It says that no statement that contains self-exculpatory matter can amount to a confession. If the exculpatory part statement is of some fact which is true, which if true, which negative, with negative the offense alleged to have been committed, alleged to have been confessed. Moreover, a confession must either admit in terms of the offense or at any rate substantially all the facts which constitute the offense. Then it says an admission that the accused is the owner of and was in recent possession of the knife or revolver which caused the death with no explanation of any other man's possession, then some confusion appears to have been caused by the definition of confession in Article 22 of the Stephens Law of Dagges, which defines confession as the admission made at any time by a person charged with a crime, stating or suggesting the inference of committing the crime. So that is how Lord Atkin is now trying to distinguish the expression confession as given by Stephen in his digest. It says, if the surrounding articles are examined, it will be apparent that the learned author, after dealing with the admission generally, is applying himself to admissions in criminal cases, and for that purpose defines confession so as to cover all the admission. So according to Lord Atkin, all admissions are confessions. In the definition given by Sir John Stephen in that regard, then in order to have the general term use of the three following articles, namely number one, confession secured by inducement made upon oath, promise deke koi you secured the admission, number one. Yeah, yes, yes, then made under a promise or secrecy, then the definition is not containing in the Evidence Act, and in that act it would be consistent with the natural use of the language construed and the statement of the accused suggesting inference in that regard. Then this is exactly the broadly explained by Lord Atkin in the Pakala Narayan Swami versus Emperor, AIR 1930 39 Privy Council, page number 47. Now the famous American author, now the Wigmore is a very eminent author from USA. His volumes are too many, more than 60 to 70 on law of evidence. Now he says a confession is an acknowledgement in express words by the accused in a criminal case. So he doesn't say implied word, he uses the word express word. There's a candid declaration by him. It is not by implication, or it is not by conduct. So he says, Wigmore says, Lord Wigmore, a confession is an acknowledgement in express word by the accused in a criminal case of the truth of the guilty fact, charge, or some essential part of it. It is to this class of statement only the present principles of exclusion applies. So that was decided by the American court in several cases. I do not want to waste your time in that regard. So this is what the section 24 speaks of, and you will come to know the entire history behind section 24, the confession and relation, when you see the judgment of our Supreme Court, state NCT Delhi versus Navjot Sandhu, the parliament attack case. All of you, the famous case, 2005 11 SCC, page number 600, or page AIR 2005 Supreme Court, page number 3820. Okay, with this I will end the topic on section 24. 25 तो आपको explain कर दिया मैंने. 25, even 26 we have covered. Now today, yes, 20, yes, that is what your question of the student. If the student has still any more question, please ask me in this regard. I am shifting to the other section now. अभी 26 तो पढ़ लिया आपने. Confession by an accused person in custody not to be proved against him. So while in custody means either in a magisterial custody or in a police custody, isn't it? He cannot make statement. Then I gave you illustration when he is supposed to be in magisterial custody from the time he is arrested under section 41, when brought pursuant to Article 22 of the Constitution of India, till the stage under 167(2), and 15 days time the magistrate can put him in magisterial custody. After 15 days time, the custody becomes judicial custody. So while in police custody, the statements are null and void. They are not to be recognized. They are not confession. Then the explanation magistrate does not include the head of the village discharging magisterial function. Now this particular expression, head of the village, has been borrowed from the judgment of the Supreme Court, which I gave it to you right now, uh, uh, Pakiri Swami versus State of Tamil Nadu, where the death take place and the accused person makes a confession before the village head. So the village head के बारे में यहाँ पे ये explanation लाया गया है, देखिए ना? Please pay attention to it. Now the very important section which I am going to take now is 27. Section 27, how much information, because 24, 25, 26 were bar. The confession cannot be received, and if they are to be received, there are certain terms and conditions. Now 27 कहता है कि how much of information received from the accused may be proved. That means यहाँ पे the accused may confess to certain crime, and pursuant to when some recovery may take place. They are called recovery deposition. Now let us see that here. Provided that when any fact is deposed as discovered in consequences of the information received from the person accused of any offense in the custody of a police officer, so much of the information, whether amounts to confession or not, relates distinctly to the fact thereby discovered may be proved. अगर accused बोलेगा police officer को, I have committed this murder, I have killed B, it is a confession hid by section 25. It cannot be proved. But if they says that if the accused, I killed the accused person B with revolver, police officer will tell him, where is the revolver? So during investigation, he will say, I have hidden the revolver in some bushes. He will take him to the garden. अगर वो गार्डन में जाके रिकवरी खोद के निकलेगी, then that is called a discovery. Now that much portion of the discovery portion is a confession. Please note that here for the purpose of section 24. So the statement which he made to the accused, to the police officer, yes, I have committed the crime. The police officer on the basis of the statement क्या करेगा? Immediately he will arrest him. Number one, the police officer will conduct the investigation. He will call the photographer. He will conduct the inquest panchanama, which you learned under the provisions of section 74, 75 CRPC. Then he will call the various panchas under section 100 of the CRPC. Panchanama lenge. Then he will call the scientific experts. DNA report निकालेगा. उसके सब report scientific examination होंगे. Isn't it? Yes, sir, this is all to be done expeditiously. Then at the time during this investigation, the police officer, maybe in the presence of the witnesses, will ask him, how did you kill this man? I killed him with a revolver. Where is the revolver? I have hidden it someplace. Now please take it to the place. अगर वो recovery होएगी, और यहाँ पे the judgment of the Supreme Court, which I quoted to you, that is right now Justice Kurdukar judgment of the Supreme Court, how the statement was made before the village panchayat head, isn't it? In that is a Pakira Swami versus State of Tamil Nadu. वहाँ पे क्या हुआ? That lady, a rich, prosperous lady, a very prosperous lady, she had a trusted servant. And she was having a lot of jewelry and gold, and the servant was well aware of this fact. वो servant की sister की शादी थी घर में. There was a marriage in the family. And she wanted to get married and give something, jewelry देना था उसको. The servant became suspicious and he became avaricious. He became, I would say, rather dishonest. He decided to kill his own master. So ये lady की क्या नाम पूरे jewelry लेने के लिए उसको मार भी दिया उसने. He killed her immediately. And the dead body was जाके कहीं छुपा दिया था उसने. And dead body witnesses were present and they have seen it here, some of them, and he was arrested. He confessed to the village officer. Then मालूम हुआ कि डेड बॉडी के अंदर when the panchas were brought, her jewelry, everybody knows in the village, she's a prosperous lady wearing diamond and gold. वो diamond and gold गायब थे body से. They were disappeared. So his confession was made to the village head is not binding. At the time, it's an extrajudicial confession. But the extrajudicial confession was substantiated. Or rather it was corroborated. You know that corroborative piece of evidence is admissible under the Evidence Act under section 156. How it is corroborated? Number one, his own evidence under section 27. Telling the police officer the dead body I have hidden at place. So dead body was exhumed or taken, देखे तो jewelry नहीं थी, number one. And he said that yeah, all my jewelry I have given to my younger sister who is about to get married. तो वहां से पूरी recovery हो गई. So the earlier statement which he made to the village panchayat, confession, that is the extrajudicial confession, at the relevant time may not be relevant, may not be admissible, but it became admissible stands proved by virtue of the recovery statement under section 27. It is called corroborative statement and the evidence of the village panchayat, who is a respected man, who is held the office here, though he is not a police officer, but he commands highest respect. So the court would brand him as a sterling witness. And he is not a chance witness. It is the accused person, he goes to him, he makes a confession. So यहाँ पे the judgment which I shared with you, that will corroborate the confession made by him to the head of the village, which was an extrajudicial confession, is corroborated when discovery take place under section 27. So 27 is lifting the embargo. So the earlier part of the statement, I committed the murder, may not be acceptable because by virtue of section 25 there is a bar. But the recovery taking place, the police officer leading him to a place, आपने कहाँ छुपाया जो आर्टिकल जिससे मर्डर किया आपने, the revolver, gun, axe, वो रिकवर हो गई. So that itself is a corroborative statement, a strong circumstantial evidence. In the case of Pakala Narayan Swami's case, the son-in-law and daughter killing the man from whom they borrowed money. His body was chopped into several pieces, put in a trunk. The trunk was purchased from the local shop and put in a rickshaw and taken to train and taken to various destination. That is how it is. You must read that case not only for the purpose of confession but also for the purpose of a circumstantial evidence. Okay. So section 27, the object of section 27 is provided for the admission of the evidence, but for the existence of the section could not be consequence of the proceeding. So section 27 stands in order to render the evidence leading to discovery of any fact, admissible information must once. So that is how it is done. Anybody want to ask me any question on 27? Please do ask. There are lots of authorities and judgment on that point. You may go through that. But यहाँ पे section 27 के अंदर the discovery part, confession which has been made, as a result of which discovery takes place, that discovery can be proved and it is a confession in the eyes of law. Okay. Anybody want to ask me question? Now I'm shifting to section 28. You may reserve your question box के अंदर. 28 पे आ जाइए. Confession made after removal of impression caused by inducement. So police officer ने promise किया था under section 24 के हिसाब से, I will see to it that I will tell the public prosecutor that you will not go to gallows. You will not go to life imprisonment. I will see to it that lesser punishment is given to you. Lesser punishment is given to you, but you admit the crime. And it's a promise. And I will see to it that your children secure, son and daughter secure medical admission. Oh, I got influence, but you admit the crime. It's a promise made. So यहाँ पे the effect of the promise can be removed by virtue of section 28. Removal of impression caused by inducement. वो promise fail हो गया, promise fulfill नहीं हुआ. Inducement निकल गया, then threat or promise, if such confession is referred to in section 24 is made after the impression caused by such inducement, threat or promise has been, in the opinion of the court, been fully removed, it is relevant. So the moment the court realizes that whatever promise, inducement which was made, that is not a permanent thing. It's a temporary promise. And he was not in the impression that lifelong he will be required to, he will believe the representation of a police officer. Or he believed the representation of witnesses from the side of the victim family. Basically, a police officer will be giving him promises. Police officer wrote a letter to the wife of the accused. Let your husband confess it. That is a proof of showing that here promise was made. Or threats were given. And if you don't sign, in one of the matters which I shared with you of a Bombay case, the Bombay case, that is I will just draw your attention. That is Percy Rustam Basta versus State of Maharashtra. Now, in that case, that was a case under the Customs Act. Now, under the Customs Act, you know that here the custom officer is not a police officer. A summons was issued by the custom officer under section 108 to the accused person that you brought several smuggled goods from Dubai, foreign country, and there was a conspiracy between you and many other people. And you make a confession that was the police officer contention. He made a confession. A confession made to a custom officer is not hit by the section 24 because custom officer is not supposed to be a police officer. He is supposed to be a revenue officer. The Supreme Court in many judgments has clarified a confession made to a revenue officer is binding and it can be a confession. The gentleman Percy took up the plea that it was hit by section 24 in as much as he threatened me that if you don't admit the factum of conspiracy, I will implicate your brother and mother in the matter. Sanjana, a very interesting judgment here. So he invoked that section, that threats were given to me, and also a promise. He made me sign an affidavit, which says that here the signing of the affidavit itself, whatever has been stated by me is true to my knowledge and belief, and nothing but the true. And if the affidavit goes wrong, and I can be booked for offenses of perjury under 193 of the Indian Penal Code. So it's a threat given by me, threat given to me by the custom officer on account of the threat of prosecution under section 193 and 340 CRPC, offenses affecting the administration of justice. And it is the confession, whatever I gave to the custom officer is not binding upon. The Supreme Court repelled both these contentions. Read the judgment of Percy, is very clear to you. So section 27 ke andar the discovery statements are admissible by virtue of section 28 when the inducement, cause, impression, threat, everything is removed with the passage of a time. The inducement was given last week, but after 10 days you make the confession. The threat was given, it was not repeatedly given. When you are produced before a magistrate, why did you not retract your statement? You are not brought it to the attention of the normally a magistrate when is brought before a police by the magistrate. He tells him क्या पुलिस ने आपको ट्रीटमेंट बराबर दिया क्या? कुछ कहना है आपको? You always notice that here, at the stage of the remand under section 167(2), every time he is produced, accused person, because now you must be seeing what is the remand stage. Now the minister of Maharashtra, who has been arrested under the provisions of a PMLA, Money Laundering Act, his custody is being extended from time to time. Every 2 days, 3 days, and 4 days. That's a remand period. So under the special laws, a different remand is there. Under the CRPC scheme, remand is different. The after 15 days ke baad, then the charge sheet must be filed within 60 days or 90 days, failing which the accused person gets a statutory bail. All of you know that. So यहाँ पे, if the accused does not complain to the magistrate that he was ill-treated, that he was compelled to record a statement, the Supreme Court has said in many cases, you are retracting your statement for the first time in 313 statement. 313 आपको तो मालूम क्या है, isn't it? Section 313 statement. Just open 313 CRPC, I will tell you क्या है. There are many times the accused person withdraws the statement confession in 313. That is a power to examine the accused. In every inquiry or trial for the purpose of enabling the accused personally to explain the circumstances appearing in evidence against him. 313. Number 1. May at any stage without previously warning the accused put up such question to him and consider necessary. This I read out to you when I am taking lectures of CRPC, but this section is relevant for the purpose of confession. Please note that. Number B, that shall after the witnesses for the prosecution have been examined and before he is called on, his defense questioning him generally on the case, provided that in a summon case the court dispenses with the personal attendance of the accused, it may be dispensed with his examination. No oath shall be administered to the accused when he is examined under subsection 1. The accused shall not render himself liable to be punishment by refusing to answer question or by giving false answers by him. Now, this subsection 3 is directly in contrast with the provisions of section in the Evidence Act 200, which is the section which renders him is bound to answer all questions. If he doesn't answer question, he can be taken to, you can sue him for perjury. That is which is the relevant section. Anybody knows? Section 132. Witnesses not to excuse from answering on the ground of answer will criminate. You are bound to answer all the question. Article 21 subclause 20 subclause 3 tells you you have a right to keep silence. You have a Miranda Rights. Miranda versus Arizona, US के अंदर follow कर रहे हैं. Article 20 subclause 3 in India, that is the Miranda Rights of the accused person. You have a right to keep mum. Don't implicate me, I refuse to answer. Following the judgment of the Supreme Court in Nandani Satpathe's case. But that Miranda rights are not available to you under the provisions of section 132 of the Evidence Act, where you are bound to answer all the questions. And even if you are criminated. But the only remedy which the court can enforce against the accused person is not to arrest him, but to prosecute him for perjury. Now, similarly, under 311 of the CRPC, and the gentleman will not be arrested. He will not be asked to take any oath. This is the explanation the court is seeking. Now, many times I have seen the advocate, defense lawyers especially, they make the mistake of informing the court that my confession has been recorded wrongly. This is not the stage. According to me, at the time when you are produced before the court and the remand stage, under the provisions of section 167(2, जब भी आप बोल दीजिए, मेरा confession जो, that's the first available step. I am retracting my statement. Or at the stage when you're applying for a bail under section 437, 439 CRPC, that is the stage you must retract your statement. Not at a stage when Ganga beh chuki hai. 311 comes into play at a last stage when the prosecution has examined its witnesses, trial has commenced. तो उस टाइम पे आप अपना confession record कर रहे हैं. That has limited value of defense, and you cannot save your client at this stage. So many of the cases which I have read, and even I would notice in the court, this is a mistake the defense lawyer make. They should not do that. Then subclause 4 says that here, the answers given by the accused may be taken into consideration in such inquiry trial and put in evidence for against him in any other inquiry or the trial for the offense which answers may tend to show he has committed. So this subsection 4 is in consonance with section 33 of the Evidence Act. You can use the evidence of a person in former judicial proceeding or in the same proceeding in a subsequent stage. So you can implicate him in that man that आपने पहली बार कोर्ट में ऐसा कहा था, आज उल्टा क्यों बोल रहे हैं? Why are you taking a so much thought? That you can contradict him, that will be helpful to you under section 145 of the Evidence Act. And impeaching the credibility of a witness under section 146 and 153 and 156 of the Evidence Act, which I will take you. Of course, we have dealt with it under subsection 5 कहता है the court may take the help of a prosecutor, defense counsel in preparing relevant questions which are to be put to the accused, and the court may permit filing of the written statement or by the accused as sufficient compliance of this section. This is very important. So notwithstanding the power to examine, this is normally power to examine comes into play no sooner the prosecution has finished his examination, finish his witnesses. The court will call upon the accused person, what do you want to please explain this? It is not, he is coming here not in a capacity as a witness. Now, the witness, after giving his evidence under 313 statement, I would not call it evidence. So this will be matters before the court. So one of the students asked me yesterday, apart from if there is no evidence, section 313 statements are not evidence, but they are matters before the court for proving, not proving and disproving. But the accused person is competent to be a witness and lead his own evidence under section 315 CRPC, which says that any person accused of an offense before the criminal court shall be competent witness for the defense and may give evidence on oath in disproof of the charges made against him. This is what the evidence. You can examine yourself, you can examine your friend, you can examine other people to disprove the case of the prosecution, that the prosecution has not proved the case beyond reasonable doubt. Now, it is not advisable at this stage, either under 313 or in 315, to say to retract your statement. You retract your statement at the stage you come to section 225, and I will tell you when. When the court is recording your plea, the best it is 225 में आ जाइए आप. 225 के अंदर the trial before the court of session commences, opening to 226, discharge, framing of a charge. Framing of a charge will take place. यहाँ पे recording of the plea shall discharge the accused if there is no material and record. Then conviction on plea. See section 229. Conviction on plea of guilty. Accused shall plead guilty. The judge shall record the plea. So यहाँ पे you can take up the plea. I do not accept this fact that I committed. So this is a stage, another stage under 229 where the accused can say, I have not committed the crime. गुनाह मुझे कबूल नहीं है. And confession जो भी record किया गया गलत record है. So that is a stage, that is a second stage. And the best stage is 167.2. When you opens 167.2 CRPC, here the accused is brought from the magistrate, from the arrested person under 167 A procedure when the investigation cannot be completed within 24 hours. So whenever a person is arrested and detained in custody, appears to the investigation cannot be completed within the period of 24 hours, fixed under 57, the ground believing the accusation found so and so, the police officer in charge may so and so, and may forthwith seek. This is the stage is brought before the magistrate. Subsection 2, the magistrate क्या कहेगा, पूछेगा इनको, magistrate to whom the accused is forwarded under this section. So the first time the accused is being forwarded to the magistrate under section 167(2), ये stage के ऊपर आप retraction लीजिए. This is the best stage. Then the magistrate, not exceeding 15 days time, he can put you, even he has no jurisdiction. This is the first available opportunity. The second opportunity comes to you when you are applying for a bail under 436, 437, 439 of the CRPC. The third stage is when a plea is being recorded. Then the fourth stage is when your statement under 311 are being recorded. And final stage is at the time when you're leading your own evidence under 315. 5 stages. But first available stage में आपको लेना चाहिए. Yeah. Next section ले लीजिए अभी आप. Yeah. 29. Confession otherwise relevant not to become relevant because of promise or secrecy. If such a confession is otherwise relevant, it does not become irrelevant merely because it was made under the promise of secrecy or in consequence of the deception practiced upon the accused person for the purpose of obtaining it when it was drunk, because he was made in answer to question which he needed to have answered, whatever may have been the form of question, or because he was not warned that he was not bound to make the concession and the evidence might be given. Now, 29 is a case where the accused may be induced to, suppose, a public servant demanding bribe. It's a demanding a bribe. You do not openly demand bribe. You will definitely demand it through agents, through agents known to both the parties. तो वहां पे आपका टेप रिकॉर्डिंग भी हो जाएगा स्टेटमेंट. So demand itself is demanded. It may be illegally. You may take up the plea that here my recording of the statement has been done illegally against the spirit of law, against the provisions of. Now, Putta Swami judgment cannot protect you. Right to privacy is abolished. Your right to privacy is not absolute. None of the fundamental rights in India are absolute. They are subject to reasonable restriction. The fundamental rights do not permit you to make a promise, do not permit you to make a demand for a bribe. So that is why in R.M. Malkani's case, 1973, when the gentleman, the coroner of Bombay, he tells the doctor who conducted the investigation, if you want me to give you a clean sheet that you have not acted diligently and the operation which have been botched up by you is not your crime, you want me to help you, and please give me this much money. The doctor in question, through whom one Mr. Motwani is in charge from the Bombay hospital, he goes and convenes that 20,000 रुपये मांग रहा तुमसे सर्टिफिकेट देने के लिए, क्लीन चिट मांगने के लिए. The doctor in charge who is says, no, I cannot give 20,000. Then the amount was reduced to 15 or 10,000. Then both of them go and report to the Anti-Corruption Bureau, who arrange a trap and recording of this statement. So the recording of this statement and tape record, that man cannot say that it is against my wish. So 29 permits here, even the statement may be irrelevant. It may be, the mode may be irrelevant. It may not be acceptable to you. Illegally collected evidence becomes relevant under section 29. Isn't it? In American judiciary, it is called fruits of the poisonous tree. Wigmore says not acceptable. But in England, it is acceptable. In India, it is acceptable. So Nagari's case, 1962, is a case where the landlord sought to bribe the police or the municipal witness. The municipal corporation had issued a notice under 354 that the building is in a ruinous condition. Demolish it. It is dangerous for the inhabitants, the passerbys. The landlord did not want to heed the notice. The landlord bolega, chalega, no problem, building is in a good condition. Why should I wait? He goes and tries to bribe the gentleman, one sheikh, who is the municipal engineer. The municipal engineer appears to be an honest man. He doesn't take the bribe. It was 100 or 200 rupees, a big money in those days in early 60s. He lodges a complaint with the Anti-Corruption Bureau. The Anti-Corruption Bureau records his statement and tape record evidence was done. And the tape record evidence, Supreme Court accepts it. And he was convicted solely on the basis of a tape record evidence, which the court said that it is a res geste evidence. It's evidence acceptable under section 7 and 8 of the Evidence Act. It is permissible to do that here. So you cannot take up the plea by virtue of the, even it may be irrelevant, it is been recorded against the provisions of particular law. It doesn't, the evidence is relevant, all your embargoes go away. The court like to see that here, facilitate. Evidence is recorded. Okay, 29 हो गया है. 20, sorry, 28, 29. 30 पे आ जाइए. Consideration of proved confession. Now I have other lecture. Tell me what time. Yeah, see, we have time. 30, 31, 30 कर लेंगे. Yeah, consideration of proved confession affecting a person making it, another jointly under the trial for the same offense. Now, more than 2 accused persons are being tried for the offenses. When more than 2 accused persons are being tried, normally 218, 219 CRPC says they can be a joint trial. आपने पढ़े हैं ना, the section 218 खोल लीजिए आप. Separate charges for offenses. For every distinct offenses, person shall be separate charges in every such offenses. Then see the proviso. Provided that way the accused person by any application and writing so desire, the magistrate of the opinion that person is likely to be prejudiced, thereby magistrate may try together all any number of charges framed against the person. Nothing in this section affect the operation of the provisions of 219, 220, 223. So यहाँ पे 219 clubbing of the charges together, a joint trial can take place under the CRPC and also in the CPC to avoid multiplicity of the proceeding, to multiplicity of the witnesses. So when a joint trial take place, joint trial के अंदर a confession made by one person, exculpatory statement involving himself and the other, then it's a confession. And if he says, मैंने गुनाह नहीं किया, दूसरों ने किया, it is not a confession. Now let us see that illustration is very interesting. Section 30, how the admission of co-accusers are confession are admissible, or examples are given in section 30. Consideration of proved confession affecting person making it and other jointly under trial for some offense, for the same offense. When more person than one is being tried jointly for the same offense, and a confession made by one of such person affecting himself and some other person is proved, the court may take into consideration such confession as against such other person as well as the person who makes such confession. Offense under this section include abatement of the accused. So there are 3 accused person, A, B, C, are held or being tried in a joint trial for the murder of D. The conspiracy to commit the murder of D. So A, B and C, A will give evidence before the court. No confession court ne record kiya police officer ne in the presence of magistrate. A says yes, we all 3 of them jointly and severally with the common intention of all. We knew there was an enmity between A and B. They brought me here. Just somebody is calling me. I will just stop it here. So when A, B and C are being tried for the murder of D, A will tell the court, yes, I agree that there was a conspiracy hatch between all three of us to eliminate D, because A had some panga with D and he paid me some consideration. I also went along. We three of us did this act. So he is implicating himself. I am a participant in the crime. So myself A, B and C together finish D. Then that confession is admissible. But if A says, I was also there. I did not do anything. I was only watching, only B and C killed. That confession is not binding because he is not implicating himself. He has to implicate. Otherwise, the joint trial के अंदर फायदा कुछ नहीं होगा. So similarly, under the provisions of section 306, you know that open कीजिए 306 में tender of a pardon to accomplice. When the prosecution in a big cases like conspiracy, like in Sheena murder case here, Mukherjees are involved in killing their own daughter. The allegations are that the mother and stepfather assassinated her with the help of the driver Roy, and the dead body was taken to पेन में कोई जंगल में जला दिए. बहुत पुरानी बात होगी. ये बात कभी उंगल के आई, निकल के बाहर आई when the other offenses were being investigated. So the police was not in a position to get the correct evidence because these are all influential people, very highly sophisticated people, and who are in touch with a lot of senior investigation agencies and many people, and it is difficult to get the crime. So police ने क्या किया? Decided to make the driver an accomplice. उसको pardon दिए, tender of pardon to accomplice. Look here, brother driver, we will not give you punishment in this matter, but you be prepared to act as our witness and tell the truth and implicate the other two accused person, namely the mother and the stepfather. Then in that event, we will hold a joint trial, you must point out. So his deposition has been recorded by the learned judicial magistrate. He has agreed to act as the accomplice. Pardon has been given. 307 में power to tender pardon होता है इसके अंदर. ये magistrate, chief judicial magistrate records it. Timing given. Now one of the condition imposed him that year, we are not going to, you are being given pardon, mean you are not going to be sentenced in this matter, provided you act as a witness, implicating the other two witnesses. वो कंडीशन का अगर ब्रीच करेगा, देन कोर्ट क्या करेगी? पार्डन को रिवोक कर देगी उसका. ही विल बी अरेस्टेड. They will be a separate trial and not a joint trial. Why? Because he has been colluding with them. His evidence is only acceptable provided he implicates the other two witnesses. Now let us see the illustration, you come to know that. Illustration A. A and B are jointly tried for the murder of C. It is proved that A said, B and I murdered C. यहाँ पे स्टेटमेंट है, B and I murdered C, तीनों को implement किया. The court may consider the effect of the confession as against B. So this is a joint trial under section 218 proviso के अंदर. Illustration B. A and his trial for murder of C. There is evidence to show that C was murdered by A, B, and B said, A and I murdered C. A and his trial for murder of C, there is evidence to show that C was murdered by A and B. that B said A unmuttered C. The statement may not be taken into consideration against B is not being tried jointly. यहाँ पे separate trial है. A, in the case of A, there's a joint trial. In the case of a separate trial, because he must have asked for a separate trial, or under 306, 307, he may not have. He may have breached the terms and conditions given here. So यहाँ पे इसका confession not binding. Okay. Now the last section here in this confession 31. Admission not conclusive proof but may stop. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppel under the provisions hereinafter contained. So they are not conclusive, mean it is not under the Evidence Act. What is conclusive? Where evidence need not be proved. That is, one illustration is section 42. The judgment, the section 41. The judgment and final decree of a competent court of probate court, matrimonial court, admiralty court, insolvency court, they are conclusive evidence. Number one, section 41. Then the second section which speaks about conclusive nature is section 120, 112, sorry, birth during marriage, conclusive proof of legitimacy. The fact that any person is born during continuance of the valid marriage, that is a conclusive evidence, unless it is proved that he did not have access to the mother. Then 113 ke andar proof of succession. Except this three section, nothing is conclusive under the Evidence Act. So section 31 says that the confession which is the admission also which is made, the admission. तो यहाँ पे 30 तक यहाँ पे confession खत्म हो गया. 17 to 23 admission and 24 से 30 तक confession. And again 31 the effect of admission, confession, 31, 32, 33. Anybody want to ask me question? I will take this remaining chapter tomorrow, and that is tomorrow mean Wednesday. I don't mind even taking one lecture tomorrow evening if you want to finish Evidence Act early. बताओ मेरे को.
Sir, we can do lectures every day or like whenever
Yes.
you are available.
Tomorrow we can take one lecture. Not fight
Sure,
problem.
sir. Sure, sir.
7
Sure,
to 8,
sir.
7 to 8 p.m. Okay.
Sure,
Good.
sir.
And if anybody has any question now, please ask me before I wind up. Tomorrow I will take 31, 32. 32 is a very longest section. It will occupy the entire session tomorrow. 31, 32 कल मैं लूँगा. Maybe try to guess. आज के लिए wind up करता हूँ. If anybody has question, I will take it up because I have another lecture of a specific relief act for the Delhi students. बताइए. Anybody has any questions? बॉक्स में कोई डालें क्वेश्चन नहीं राघव, क्या नाम है कुमार?
No, sir. We
No question.
haven't received any
So
question.
any
No,
questions
sir.
are coming here, we can ask tomorrow. Tomorrow 7 to 8. Okay.
Sure, sir. Sure, sir.
Okay. Okay. Good night. Hopefully you understood the lecture, all of you.
Yes, sir. Yes, sir.
Okay.
Thank you
Bye. Good
so
night.
much, sir. Good night, sir.